Justice Sotomayor. Justice Kagan.
General, there seems to be a fair bit of division and a fair bit of confusion about what Bruin means and what Bruin requires in the lower courts. And I'm wondering if you think that there's any useful guidance, in addition to resolving this case, but any useful guidance we can give to lower courts about the methodology that Bruin requires be used and how that applies to cases even outside of this one.
Yes, I think that there are three fundamental errors in methodology that this case exemplifies and that we are seeing repeated in other lower courts, and that this case provides an opportunity for the court to clarify that Bruin should not be interpreted in the way that respondent is suggesting. The first error we see is that respondent has asserted here, and other courts have embraced the idea that the only thing that matters under Bruin is regulation. In other words, you can't look at all of the other sources of history that usually bear on original meaning. And I don't think that that can be squared with this court's precedent, starting with Heller, which consulted a wide variety of historical sources, the same kind of evidence we've come forward with here about English practice, state constitutional precursors, treatises, commentaries, state judicial decisions. All of that is relevant evidence about the scope of the Second Amendment right, and I think the court could make clear that it's not a regulation-only test. Second, I think that looking just at regulations themselves, one of the fundamental problems with how courts are applying Bruin is the level of generality at which they're parsing the historical evidence. Court after court has looked at the government's examples and picked them apart to say, well, taking them one by one, there's a minute difference between how this regulation operated in 1791 or the ensuing decades and how Section 922 provisions operate today. And I think that comes very close to requiring us to have a dead ringer when Bruin itself said that's not necessary. The way constitutional interpretation usually proceeds is to use history and regulation to identify principles, the enduring principles that define the scope of the Second Amendment right. And so we think that you should make clear that courts should come up a level of generality and not nitpick the historical analogs that we're offering to that degree. And third and finally, I think that in many instances, courts are placing dispositive weight on the absence of regulation in a circumstance where there's no reason to think that that was due to constitutional concerns. So for example, here we don't have a regulation disarming domestic abusers, but there is nothing on the other side of the interpretive question in this case to suggest that anyone thought you couldn't disarm domestic abusers or couldn't disarm dangerous people. And in that kind of context, I think to suggest that the absence of regulation bears substantially on the meaning of the Second Amendment is to take a wrong turn. It's contrary to the situation the court confronted in Bruin, where there was a lot of historical evidence to say states can't completely prohibit public carry. And against that evidence, you might say that the absence of regulation is significant. But here, there's nothing on the other side of this interpretive question, and I think that that just shows that you shouldn't hold the absence of a direct regulation against us.
Thank you.